Ed, Nisqually, your name, please.
My name is what you asked
Yes.
for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capitals.
In this opening section, the interaction immediately establishes the typical sovereign-citizen dynamic, where the defendant tries to complicate the simplest question, his name, by hiding behind meaningless pseudo-legal jargon. The judge remains calm and professional, while the commentary highlights the absurdity of the agent authorized to represent nonsense. This part shows how sovereign citizens often believe that manipulating language somehow confuses legal identity, when in reality, it only makes their situation worse. The commentary emphasizes how these tactics don't impress the court and only make the defendant seem deliberately uncooperative. It also underlines the comedic contrast between the judge's patience and the defendant's self-created confusion. Overall, this part reveals how such antics rarely achieve anything beyond demonstrating the defendant's misunderstanding of basic law.
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting
I read him.
Langley
I
go.
read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, that language doesn't make any sense. So
No, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's in
I'm
all
not a
caps.
person.
This portion focuses on the judge's attempt to determine competency, while the defendant continues to insist he is a sovereign being, prompting the commentary to highlight the irony in claiming special legal status while demonstrating a lack of basic comprehension. The judge tries to bring the conversation back to reality, but the defendant keeps derailing with philosophical wordplay that holds no legal relevance. The commentary notes how the sovereign citizen mindset relies heavily on redefining simple words like people and person, yet none of these redefinitions help them inside a courtroom. This part shows how courtroom patience is tested by such antics, and how the judge must constantly balance firmness with politeness. It illustrates the recurring pattern where sovereign citizens sabotage themselves long before the actual legal arguments even begin.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application will be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was.
In this segment, the commentary expands on how the prosecutor calmly lays out the facts while the defendant keeps interrupting, creating a noticeable contrast between professionalism and disorder. The details about the 7-Eleven incident show how straightforward the case is, making the defendant's dramatic language seem even more misplaced. The commentary highlights the humor and frustration in seeing someone argue sovereignty while also admitting to drunken behavior. It also emphasizes how the officers treated him fairly, giving him multiple chances before arresting him, which undercuts any claim of victimization. This part reveals how sovereign citizens often create problems for themselves and then attempt to portray ordinary consequences as injustices.
Have to do. Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Squally jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Now, will I get a moment here to...
Here, the commentary points out the comedic absurdity of the defendant claiming he was too drunk to be held accountable, a line that defies both logic and legal standards. It emphasizes how rare and bizarre it is to see someone openly admit to misconduct while simultaneously arguing that intoxication exempts them from responsibility. The prosecutor's narrative makes the defendant's behavior appear repetitive and predictable, showing that he was given leniency before choosing to violate the trespass order again. The commentary underscores how self-incriminating statements like these undermine any potential defense. This part shows how the defendant's approach is more damaging to himself than anything the court could do.
So, Ms. Sharp, it appears that the assault was not a deferral, it was a stipulated order of continuance.
That's correct, Your Honor.
All right, thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. I will. And Mr. Milton is asking not to be represented by counsel, is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice, but I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar, is that correct?
This section focuses on the judge formally acknowledging the city's request to revoke a previous agreement due to the new offense. The commentary highlights how the defendant continues to misunderstand courtroom procedure, trying to argue while the judge is addressing administrative matters. It points out how sovereign citizens often demand to be heard at inappropriate moments, thinking they can control the flow of proceedings. The judge's professionalism stands in sharp contrast to the defendant's chaotic communication style, reinforcing how structured legal systems operate regardless of personal beliefs. This part underscores the gap between sovereign citizen expectations and actual legal procedure.
Court cannot assist you in recognition of the fact that you're not an attorney, so you will end up missing things you're supposed to do, you will do things you're not supposed to do, and all of those things will likely work to your detriment So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay,
Your Honor.
even know the right term, okay? All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke these continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Your Honor, I was not read my Miranda rights this.
In this portion, the commentary discusses the judge's patient explanation of the right to counsel and the dangers of self-representation, especially for someone who clearly lacks legal knowledge. The defendant's refusal to confirm basic facts, such as not having a law degree, adds to the comedic tone as he attempts to maintain a sense of mystery or authority. The commentary emphasizes that courtroom reality does not bend to personal theatrics, and the judge makes that clear while still respecting the defendant's rights. This part demonstrates how sovereign citizens often reject legal assistance while being unaware of how deeply that harms their case. The judge's warning also shows a clear attempt to protect the defendant from self-inflicted consequences.
Internet access so that I can properly represent myself. If you would
Okay,
write that into a court
Read
order.
your form on your constitutional rights.
Did I read my form? I don't believe I was provided anything,
Okay, is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay, why don't you take a minute and read it? Let me know when you're done reading it, Mr. Milton.
Appreciate you. I haven't
Oh,
been
reading.
Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this.
The commentary highlights the defendant's misguided attempt to invoke Miranda rights as a shield against charges, revealing a fundamental misunderstanding of when those rights apply. The judge's response shows that sovereign arguments collapse instantly when confronted with basic legal clarification. The commentary stresses how the defendant confuses procedural matters with magical loopholes, believing that saying certain phrases grants immunity. The contrast between the defendant's confidence and his lack of comprehension creates a humorous but frustrating dynamic. This part illustrates how sovereign citizens often mimic legal terminology without understanding purpose, timing, or context.
Would you please silence yourself? Forgive me.
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Several days later.
I have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so with the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was
Okay, yeah, hold
Not in
on.
possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
This section focuses on the judge giving the defendant time to read his rights form. While the commentary notes the irony of someone claiming superior legal understanding, yet struggling with the most basic instructions, the defendant tries to assert authority by demanding silence from the judge, which only exposes his lack of awareness regarding courtroom hierarchy. The commentary emphasizes how sovereign citizens frequently mistake defiance for empowerment, not realizing it weakens their position. The judge remains composed throughout, demonstrating the patience required to handle such defendants. This part showcases the comedic yet tragic pattern of unnecessary confrontation, driven purely by misunderstanding.
And I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say can be used against you. That's the whole purpose of Miranda. Doesn't mean they can't go forward with a criminal charge.
Oh, I was never aware of that.
Right. Which is one of the reasons you don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay. All right. See you much.
In this portion, the judge discusses bail while warning the defendant not to discuss facts of the case, yet the defendant immediately begins doing exactly that. The commentary shows how sovereign citizen confidence often leads directly to self-incrimination. His explanation about his belongings being stolen and past arrests appears unrelated and unhelpful, revealing his tendency to rely on emotional narratives instead of legal arguments. The commentary highlights how the defendant interprets every unrelated frustration in life as part of some grand injustice, reinforcing the sovereign citizen mindset. This part illustrates how personal grievances are mistaken for legal defense, undermining his credibility further.
$500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol, marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is $300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be.
The final part's commentary focuses on how the defendant wastes his single opportunity to argue against bail by delivering irrelevant accusations and personal complaints. Instead of addressing risk of flight or likelihood of returning to court, the actual purpose of a bail hearing, he dives into unrelated stories that only harm his position. The commentary highlights how sovereign citizens often mistake storytelling for strategy, failing to understand what judges evaluate. The judge's decision is shaped not by emotion, but by procedural requirements, which the defendant continually avoids addressing. This part emphasizes how sovereign citizen behavior turns simple hearings into unnecessary complications that ultimately work against them. It closes with the clear impression that the defendant's downfall is largely self-inflicted through misunderstanding and stubbornness.